it's time for some legal advice with our good friend, attorney David Aylor. And today we're discussing car accidents and what to do when the other driver is found at fault. David, welcome, as always.
Good morning.
And I'm sure that's maybe a frequent problem, you know? The other driver's at fault, you know, what's your next step?
Right, and a lot of people don't really know what their next step should be. Obviously, the first step should be get some medical care if they feel like they need any, either on the scene or then sometime quickly thereafter. Second to that, you're also going to look at determining exactly what the damage is to your vehicle. And what's usually going to happen is you're going to be contacted by their insurance company fairly quickly, and that's where it can get a little bit dicey.
Okay, so let's say you're in an accident, you get medical care, and then their insurance company contacts you. How do they proceed from there? Like, what's the typical protocol?
Usually they're going to want to try to get a statement from you very quickly, which I never suggest that being the best step for you, because simply they want you to try to say things that are going to lessen the potential damages related to the car, and of course, most importantly, related to potential medical damages that you may have or someone in your car has sustained from the actual accident. So I always suggest that people, at least at a minimum, consult with an attorney first before making that statement, because even though the insurance folks on the phone seem very nice, you have to remember that they're in a for-profit business and they're not working for you, they're working for the other driver and ultimately themselves.
And I'm sure you've seen that happen where someone makes a statement to the insurance company, it maybe screws things up a little bit, and then they come to you. Is it too late?
It's not too late. It obviously can damage your potential case and your potential recovery when you make those early statements, as well as if you ignore maybe aches and pains you may be having. Somebody sometimes will get in an accident and say, hey, I think I'm going to take a check from an insurance company. They said they're going to pay twice what my property damage was and $500 more. Well, then they take that, and then 2 weeks later they find out they've got a torn rotator cuff. Well, at that point, it's too late. You have to get that medical care as quick as possible, and before taking any kind of settlement, you want to make sure that you're completely cleared medically, because a lot of people don't understand that once you actually take any kind of settlement, no matter what it is, at that point the insurance company is no longer liable, even though you may have injuries that are reoccurring or that have not been discovered yet related directly to the accident.
Do you have any hard numbers? Say someone went to you and was like, they're offering me $5,000, where you could double that number, or something. You know, like it's got to be a very big difference sometimes.
Right. You know, a lot of times people will say, well, I didn't want to use an attorney because I didn't want to bring in an attorney for them to get a potential part of the fee. Or they may not understand that an attorney's not going to most often take any fee on the front end, meaning they're only going to take a percentage with a contingency-based thing. So what you end up looking at is, okay, what numbers are we looking at? Well, the biggest part of it is if you're going against an insurance company and you're not an attorney, the insurance company quickly realizes there's only so far you're going to go. Now, could you go ahead and file your own lawsuit? Of course you could.
Sure.
It's highly unlikely that you would. So therefore, when they hit a certain point, that they're not going to push it any further, because they know that you're not going to litigate it any past that as being a person that's pro se representing themselves.
And that's a great point, because a lot of people, I think, assume they have to pay you several $100s, $1,000, whatever, up front. But a lot of times it's just the consult and it's not the back end.
Yeah, exactly. And just as important as that, and probably more important, is the medical side of it. People are like, well, I was going to the doctor, but I stopped because I couldn't afford it. Well, when you have an attorney, they can write what they call a letter of protection and put that in place with the medical provider saying, hey, this is now in litigation, hold the bills, don't put them against them, don't make them pay, and then we'll close it out on the back end. So you can actually continue to get that treatment with also not having to put up that upfront money.
Always great information. And before I forget, you are having a school supply drive at your office.
Right.
Tell me more about that.
We are. We're doing it for the Pace Charter School, which is a local special needs school. They need anything you can think of school supplies-wise, as well as household items like paper towels, you know, Kleenex, anything like that. And we're taking them at both my locations in the Charleston area, 3844 Leeds Avenue, and downtown at 24 Broad Street. So if you have anything like that that you can help us with, please just drop them by, and then we're making sure they all get delivered to Pace Charter School.
Every kid needs that, yeah.
Absolutely.
Thank you so much for being here.
Thanks for having me.
Attorney David Aylor, and we have much more right here on Low Country Live, so stick with us.